right, so Mr. Moore,
Yes, ma'am.
what were your issues on this day? I don't understand anyone chasing after their mom with a knife.
American Justice Vault.
All right, the court is calling 2022 CR 1175, State of Texas versus George Moore. Could I have parties announced for the record for the state?
Michael Villeray, after the state.
For the
Russell May
defense.
on behalf of Mr. Moore present on bond, ready for sentencing. I mean, for plea.
And are you Mr. Moore?
Yes, ma'am.
Mr. Moore, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, and we have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moore, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, state's proceeding on count one and waiting any count two.
Any objection?
No objection, Your Honor. It's our understanding of the agreement.
Mr. Moore, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, and for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am. I did.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. Punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am. I did.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain
It
agreement?
is, Your Honor. There are no children or marriage in this case.
All right, state is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with
Yes,
your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
None at this time, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours of community service, restitution hours, no harmful or injurious contact with both Collins and Ellen Collins, and the hostility and aggression control course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state upper state exhibit number one and its attachments.
We've reviewed the document, Your Honor.
Any objections?
No objections, Your Honor.
Mr. Moore, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and agree the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. adjudication. Are you proceeding with sentencing?
You are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, on behalf of my client, with the state's permission, 5 years was the agreed, Your Honor, but I'd like the court to know my client was on full house arrest for over a year at the residence, Your Honor. I asked the court to consider reducing.
At what residence? The complainant's residence?
Yes,
Okay. All
and
right.
asked the court to consider, Your Honor. And his parents are here, reducing the 5 years to 4 years, Your Honor, with the credit for that time.
All right. And Mr. Villarreal, with regards to the no harm for injurious contact with Bo Collins and Ellen Collins.
They're both, we've spoken to them particularly about this issue. They want to continue to have contact with him. So that's the reason for the state's recommendation.
All right, so is he actually living in the home with Bo and Ellen?
I'd have to double check the court file about that in particular, but I have no reason to believe that what Mr. Bartolome is saying is incorrect.
Only with this mom, Your Honor.
Okay. All right, so Mr. Moore,
Yes, ma'am.
what were your issues on this day? I don't understand anyone chasing after their mom with a knife.
Ma'am, I used to have a really bad opiate and benzo addiction for about 5 years. And after that time, I quit. And I've been on Suboxone treatment ever since. And I've been doing a lot better. And I just wasn't in the right state of mind. I was blacked out. I regret it. It's embarrassing.
All right, what do you do for a living?
Nothing right now, but I'm working on getting into work with my dad. I know how to cut glasses and put prescriptions in frames and stuff like that.
His father's an optician, Your Honor.
So how old are you?
I'm 22. I'll be 23 in June.
So what degree or what do you have in order to put prescription in glasses?
No degree. I was self-taught, or not self-taught, but I was taught by like other work opticians, and my father taught me how to in the lab.
All right, should I trust him with my prescription glasses?
Well, Your Honor, I think over time, but he is monitored, Judge. My father was an optometrist, so I have faith in lay people knowing how to do that, Judge.
Did you ever do it?
I learned how to do it when I was 10, Judge.
Should I trust you with that?
You should, Judge. They were ground right, but that's in the days when we ground them on the mill and you put the mud on it and continued to shape the lens. Today they're popped in with prescriptions almost.
All right, see, Ed, you're throwing out a little stuff to make me feel like you actually did it.
I did, Judge.
Okay. It's like, how do you make cake? Oh, you just do flour and eggs, you know, put the icing on there.
A chef judge.
Yeah. All right, so this is what the court is going to do. The court is going to do a $1,500 fine, probated. There's an affirmative finding of family violence. And I'll note for the record that the parents are in the courtroom and they want to have contact with you. There's to be 120 hours of community service restitution. 40 of those hours will be waived to provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, you provide proof. 40 of those hours will be waived. There's to be no harm for injurious contact with Bo, B-E-A-U, Collins, C-O-L-L-I-N-S, and Ellen, E-L-L-E-N, Collins. The hostility and aggression control force. All right, who are you seeing for your issues with drugs? Because it takes more than just taking a drug to get off drugs.
Right. I cannot think of my doctor's name off the top of my head, but I go to a health net clinic over off of I think 410.
Okay, and other than giving you the medication, what are they doing?
They're providing counseling and stuff like that.
All right, he's to do continued counseling and provide proof
Yes, ma'am.
of counseling and provide a release. So you're gonna have to do a medical release with probation
Yes, ma'am.
so they can see what's happening.
Okay.
There's to be regular reporting by Zoom or in person. If you can't report in person, then, if you can't report by Zoom, then you need to report in person. So probation may still be doing Zoom, they may decide to do in person. I'm gonna want field visits 2 times per month, random. There's going to be 5 years deferred adjudication. You can always ask to be taken off early if you abide by the rules.
Yes, Judge.
So whether or not you're off early or consider releasing you early depends on your actions. You understand?
Yes, ma'am. Yes.
Proof of employment within 40 days. There should be no employment as a home health care provider or with minors. Let's see if there's anything else that you need. Just a moment.
Your Honor, will there be a period of time for home visits where we can reapproach the court for that?
Yes.
How
There's
long?
no, I usually, I will receive reports from probation, and probation will tell me, we've been visiting them for 3 months. Could we consider something else? There's an affirmative finding of family violence. Ms. Abrams, is there anything else that he needs?
Your Honor, did you mention a TAP eval? Did you want a TAP eval?
He's already under care of a physician and receiving counseling, so we're just going to continue with that. But
Okay.
if his ways, if they end up being positive, then the court will reconsider.
Okay, I think that's all.
All right, is there anything else you need from the court in order to be successful? All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's
Thank you, Your Honor.
permission to appeal. Do you understand?
Yes, ma'am. I do.
Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question about what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am. I do.
All right, we can go off the record. Probation will meet with you and go over your conditions, and maybe you should just stick to butter knives,
Yes, ma'am.
which for some reason, that's all they give you at restaurants now. They don't trust you with a steak knife.
Thank you, Judge.
What started as a moment of chaos could have ended in a lifetime behind bars. But for George Moore, this was a second chance wrapped in strict conditions and serious consequences. At just 22 years old, standing in front of the court after chasing his own mother with a knife, the reality of his actions finally caught up with him. The judge made it clear this wasn't just about punishment, it was about whether he could truly change. Deferred adjudication means he walks out of that courtroom today without a conviction. But one wrong move, one failed test, one violation, and he could be facing up to 20 years in prison. That's the weight now hanging over his future. The court gave him an opportunity, but not without watching his every step. Counseling, supervision, employment, and strict rules he cannot afford to break. The real question is, will he rise from his past or fall right back into it? Because stories like this don't end in the courtroom, they begin there. Now it's up to George Moore to prove that this wasn't just another excuse, but a turning point, a chance to rebuild trust, repair family bonds, and finally take control of his life. But if history repeats itself, the next time we see him, it won't be for probation. It'll be for sentencing.